What if the law decided your fate in days, not years? What if one mistake meant death with no second chance? Tonight, we step into America's darkest justice era. Stay with us, because once this story starts, there's no appeal. The switch is ready. The room is quiet. A man stands only a few steps from death. There is no higher court to save him, no last call for mercy, no appeal left to file. In 19th century America, this moment came fast and often without warning. When the sentence was read, the end was already decided. As guards move closer, the man whispers that he is innocent. The witnesses are gone. The jury has disappeared back into normal life, and history is about to decide whether the law has just killed the wrong person. But how did America reach a place where a human life could end so quickly, with almost no chance to stop it? To understand this moment, we must go back to a time when the justice system moved faster than truth. Before 1900, the idea of appeals barely existed for most prisoners. Courts believed juries rarely made mistakes. Judges trusted first trials, and the public wanted punishment, not questions. Once a person was convicted of murder, the path to death row was short and cruel. In many states, there was no automatic right to appeal a death sentence. If a prisoner wanted another hearing, it depended on money, political influence, or pure luck. Poor defendants, immigrants, labor activists, and Black Americans almost never got a second chance. Trials could last only a few days, evidence was weak, confessions were often forced, and lawyers were sometimes untrained or absent. One of the most famous real cases that shows this deadly system was the Haymarket Affair of 1886. After a bomb exploded during a labor protest in Chicago, 8 anarchists were arrested. Some were not even at the scene when the bomb went off. There was no proof tying them directly to the act. Still, the jury convicted them. The judge made it clear that their beliefs mattered more than evidence. Appeals were rushed and limited. Within months, death sentences were confirmed. 4 men were hanged in 1887. 1 died by suicide in prison. Later, even the governor admitted the trial had been unfair. But by then, the rope had already done its work. This was not rare. Across America, executions happened in county jails, state prisons, and public gallows. Newspapers printed names like announcements. Crowds gathered, children watched, and the justice system rarely looked back. Another real example came in 1890 when William Kemmler became the first person executed by electric chair in New York. The state rushed to prove a new method of death was more humane. His appeals failed quickly. The execution itself went wrong, lasting far longer than planned. Witnesses were horrified, yet the courts refused to slow down or admit error. Progress mattered more than the man. Inside prisons, inmates on death row lived with constant fear. There were no fixed execution dates at first. Prisoners could be called from their cells with little notice. Some waited weeks, others waited years, not knowing when the end would come. Guards avoided eye contact. Silence filled the halls. Hope slowly disappeared. Wrongful convictions were later uncovered, but only after executions had already taken place. New witnesses came forward. Confessions were proven false. Evidence was found to be planted or misunderstood. But before 1900, there was no system to correct these mistakes in time. The public trusted the law. Judges trusted the process, and prisoners paid the price. As the century neared its end, whispers of reform began to grow. Some lawyers questioned fast trials. Some journalists exposed corrupt courts. But death row kept filling, executions kept happening, and appeals remained out of reach for most condemned inmates. Now, return to that silent room. The guards step closer. The man takes one last breath. The system has decided. Whether it is right or wrong no longer matters. And just before the final moment arrives, a message is handed to the warden, a message that could change everything, or arrive too late. If you think this chapter was shocking, the next chapter reveals how entire groups were sent to death row with almost no defense at all, and how one case nearly broke the American justice system forever. The cell door opens without warning. The condemned man does not scream. He does not fight. He already knows what this sound means. In prisons across America before 1900, that sound ended lives. No letter from a higher court, no pause, no judge stepping in at the last second. When the guards came, it was over. For many prisoners, the law had already forgotten them. But this chapter is not about one man. It is about groups of people who were sent to death row almost as a rule, not because the truth was clear, but because the system had already decided who was disposable. After the Civil War, America changed fast. Cities grew, factories spread, workers protested, immigrants arrived by the millions. Fear followed close behind. Courts became tools to restore order, and death sentences became warnings to everyone else. Poor defendants suffered the most. Many could not read. Many did not understand the charges against them. Some never met their lawyers before trial. In rural courts, trials could last only a single day. A jury would be chosen in the morning. A verdict would be read before sunset. Black Americans faced an even harsher reality. In the South, all-white juries decided cases involving black defendants accused of killing white citizens. Evidence did not need to be strong. Rumors were often enough. Appeals were almost never allowed. Executions followed quickly, sometimes within weeks. One real case that shows this injustice clearly happened in 1892 in Arkansas. A group of black men were accused of murder during a labor dispute at a cotton plantation. The trial was rushed. Defense lawyers were threatened. Witnesses were silenced. The jury delivered death sentences after barely any discussion. When the case reached the Supreme Court years later, the court admitted the trial had been unfair, but by then, several of the men were already dead. Justice arrived too late to save them. Immigrants were another target. In cities like Chicago, New York, and Boston, foreign-born workers were often blamed for violence during strikes. Courts treated political beliefs as crimes. If someone was labeled an anarchist or radical, guilt was assumed. The Haymarket executions were not the only example. Across the country, suspected radicals were jailed, beaten, and convicted with little proof. Appeals were denied because judges feared unrest more than injustice. Keeping control mattered more than finding truth. Inside death rows, prisoners began to understand something terrifying. Innocence did not protect you. Silence ruled the cells. Some inmates wrote letters begging for help. Most letters were never answered. Newspapers moved on. New executions filled the headlines. By the 1890s, the public started to see cracks in the system. Journalists exposed corrupt judges. Lawyers admitted trials were rushed. Some governors quietly commuted sentences to avoid scandal. But these were rare acts of mercy, not legal rights. One case shook the nation more than most. In 1896, a man was sentenced to death based almost entirely on a forced confession. Witnesses later admitted they lied. Physical evidence did not match the story. As execution day approached, public protests grew. Clergy begged the governor to intervene. The governor hesitated. He knew stopping the execution could make him look weak. Letting it continue could mean killing an innocent man. Appeals had already failed. The law offered no clear escape. This was the moment America faced its own reflection. Was the justice system about truth or speed? Was death row about safety or fear? As midnight approached, the prison prepared for another execution. Guards checked locks. The chaplain waited. Outside, crowds gathered, arguing, praying, shouting. Inside the cell,
The prisoner listened to footsteps that might be his last, and just hours before the execution, a new witness arrived with information that could change everything. But the law had already spoken, and the clock did not stop. In the next chapter, we step inside the final hours on death row, where time, hope, and humanity disappeared one execution at a time, and where one final case would force America to confront the cost of punishment without appeal.
The final night always felt longer than the rest. Inside American prisons before 1900, time behaved differently on death row. Minutes stretched, footsteps echoed louder. Every sound carried meaning. When guards walked past a cell, prisoners stopped breathing. Was this the moment, or just another reminder that it was coming? For many condemned inmates, this was their last night alive, and they knew it. There would be no phone call, no emergency order from a distant court. Appeals were finished long ago, sometimes within days of sentencing. The law had closed its doors, and silence filled the space where hope once lived. Real prison records from the late 1800s show how final hours unfolded. Prisoners were often told the exact date of execution only shortly before it happened. Some were informed the same day. The system believed this reduced unrest. In reality, it crushed the human spirit. One inmate wrote a letter in 1894 from a New York prison just hours before his execution. He said he was not afraid of death, only of being forgotten as a criminal instead of remembered as a man. His guilt was still debated years later, but the execution moved forward without delay. This was common. Death row before 1900 was not a single hallway or special unit. In many places, condemned inmates stayed in regular cells until the final day. They watched other prisoners come and go. They heard laughter, arguments, footsteps, life continuing while theirs quietly ended. Chaplains visited often. Guards avoided long conversations. Some guards admitted later that death row duty haunted them more than any other assignment. They knew the system they served did not always get it right. Executions themselves were treated as official business. Paperwork was prepared. Witness lists were written. Governors sometimes stayed awake all night, waiting for possible last-minute news. But unless a powerful person intervened, nothing stopped the process. One real case in 1898 exposed this cruelty clearly. A man convicted of murder in the Midwest maintained his innocence from arrest to execution. New evidence surfaced days before his scheduled death. A witness recanted. Another admitted being pressured by police. The governor received the information, but there was no legal requirement to pause. The appeal window had closed. The courts had ruled. If the execution stopped, it would be a personal choice, not a legal one. The governor delayed for hours. As dawn approached, he chose not to intervene. The execution went forward. Years later, historians confirmed the man was likely innocent. Stories like this spread quietly after executions were complete. They rarely made headlines at the time. Newspapers focused on crime, not mistakes. Public faith in the system depended on belief, not doubt. Inside prisons, other inmates watched death row with terror. Some stopped sleeping, others prayed, a few became numb. Everyone understood one thing clearly. Once sentenced, you were already dead in the eyes of the law. By the late 1990s, pressure for reform finally began to rise. Lawyers argued that speed was replacing justice. Journalists exposed cases where appeals were denied despite obvious errors. Religious leaders questioned whether the state should have such final power. But reform came slowly. Executions continued. Death row remained a place where truth often arrived too late. One final case before the turn of the century forced the nation to look again.
A condemned prisoner had overwhelming evidence of innocence discovered after trial. Public outrage exploded. Newspapers demanded action. Protests filled the streets. This time, the governor stopped the execution. It was one of the rare moments mercy broke through the system. That single decision did not end punishment without appeal, but it cracked the foundation. Slowly, states began adding appeal rights. Death sentences faced more review. The system learned, painfully, that speed could not replace truth. Yet, for the thousands executed before 1900, reform came too late. Their names faded, their cases gathered dust, their lives ended without a second chance. And as the 20th century began, America carried a heavy question forward. How many innocent people had been executed simply because the law refused to wait? In the next chapter, we confront the legacy of this era, the forgotten names, the hidden mistakes, and the question that still follows the death penalty today. How many lives were lost to punishment without appeal? The execution was over before the sun fully rose. By morning, the prison yard looked the same as it always had. Guards returned to their posts, clerks filed paperwork, another name was crossed off a list. In America before 1900, this was how death row worked. The system erased people quietly, then moved on as if nothing had happened. But outside prison walls, something had begun to change.
Families of the executed started asking questions. Journalists began digging into old trial records. Lawyers reread transcripts and noticed how thin the evidence really was. Slowly, painfully, the truth surfaced. Many people sent to death row in the 1800s were never given a real chance to defend themselves. Real cases kept appearing. In one state, a man executed for murder was later proven innocent when the real killer confessed years later. In another, a witness admitted lying after police threatened arrest. These stories spread after death when nothing could be undone. Appeals had been denied. Governors had stayed silent. The law had already finished its work. Before 1900, the justice system valued final decisions more than correct ones. Courts feared that allowing appeals would weaken authority. Judges worried that slowing executions would invite chaos, so they chose speed, they chose certainty, and they chose death. But the cost was human life. By the late 1990s, reformers began to use one word again and again: mercy. They argued that justice without mercy was not justice at all. They pointed to death row as proof that the system could not be trusted with absolute power. One real turning point came when several states quietly changed their laws. Appeals became possible in limited cases. Governors used clemency more often. Executions slowed slightly. These changes were small, but they mattered. Still, for most prisoners sentenced before 1900, reform came too late. Their stories were never recorded fully. Many had no photographs. Some had no graves marked with names. All that remained were court documents and execution dates. History remembers the system, but often forgets the people. And that may be the deepest punishment of all. Death row before 1900 was not just about punishment for crime. It was about fear. Fear of disorder, fear of outsiders, fear of change. When fear ruled, truth became optional, appeals became unnecessary, and human life became replaceable. As the new century approached, America stood at a crossroads. It had seen what punishment without appeal could do. It had watched innocent lives vanish behind prison walls. The question was no longer whether mistakes had been made. The question was whether the country would learn from them. Today, when appeals take years, when cases are reviewed again and again, those delays exist for a reason. They are echoes of the past. They are scars left by the men and women executed too quickly, too quietly, too wrongly. Their final moments still whisper a warning. When justice refuses to wait, truth is often the first thing to die.
And the next time a system claims it cannot slow down, history reminds us what happens when punishment comes without appeal. If this story made you question what justice really means, the next chapter will uncover the forgotten names behind these executions and the cases that still haunt American prisons today. The names were written in ink that never expected to be questioned. Inside old courthouse ledgers, prison logs, and yellowed execution records, thousands of condemned prisoners were reduced to a few cold lines: name, crime, sentence, date of death. No space for doubt, no space for innocence. Before 1900, once your name entered that book, it almost never came out. But long after the executions ended, the dead began to speak. Historians, lawyers, and journalists started reopening forgotten cases in the early 1900s. They did not begin with sympathy, they began with facts. Trial records were missing, evidence had been destroyed, confessions were written in handwriting that did not match the accused, witness statements changed again and again. What they found was terrifying. In case after case, the same pattern appeared: a rushed arrest, a fast trial, a jury under pressure, a judge unwilling to delay, and a man or woman sent to death row with no real way to fight back. One real case uncovered years later involved a farm worker accused of killing his employer in the 1890s. He spoke little English. His lawyer met him once. The jury deliberated for less than an hour. He was executed within months. Years later, records showed another worker had confessed privately, but no one listened in time. There was no appeal. There was no pause. Families carried the pain quietly. Many were too poor to challenge the courts. Others were too afraid. Speaking out against the system could bring retaliation, so they buried their grief along with the truth. Prisons also kept secrets. Wardens destroyed letters written by condemned inmates. Guards were told not to speak about doubts. Some admitted later that they suspected innocence, but believed it was not their place to interfere. The system trained them to obey, not to question. As the new century approached, death row slowly changed. Appeals became more common. Executions moved behind closed doors. The public no longer watched, but the past never disappeared. It waited. Each time a wrongful conviction was uncovered decades later, it pointed back to the same era, the time when punishment came without appeal. By the mid-1900s, scholars estimated that dozens, possibly hundreds of executions before 1900 were deeply flawed. Some involved false confessions, others relied on witnesses later proven unreliable. Many involved defendants who never truly understood the charges against them. And yet, there were no apologies, no memorials, no official list of the wrongfully executed. Their punishment did not end with death. It continued in silence. Today, when courts argue about delays, when appeals take years, critics often say justice is too slow. But speed was once the problem. Speed filled graves. Speed buried truth. Speed allowed fear to rule the law. Every appeal now exists because someone before 1900 never had one. Every delay carries the memory of a life lost too fast.
Death row before 1900 was not just a place. It was a warning, a system that believed it could not be wrong, and therefore never stopped to check. As the records fade and the names disappear, one question remains unanswered. How many innocent people were executed simply because no one was allowed to ask again? And if the system once made those mistakes, could it ever happen again? That question still hangs in the air, heavier than any prison door. If you want this story to continue deeper into the forgotten cases and reveal specific names history tried to erase, the next chapter will take us inside the files that were never meant to be opened. The files were never supposed to be opened. They sat in basements, locked cabinets, and forgotten storage rooms, court records stamped closed, prison logs marked final, execution reports signed and dated as if nothing more needed to be said. Before 1900, once the state killed a prisoner, the story officially ended. The law did not look back, but history did. As decades passed, researchers began comparing cases. Names appeared again and again across states. Same charges, same weak evidence, same rushed trials, different prisons, different gallows. The pattern was impossible to ignore. One by one, the truth emerged. In several real cases, later investigations showed that juries had been misled. Judges had blocked testimony. Police had pushed witnesses to say what they wanted. Confessions were signed after hours of questioning, sometimes by men who could barely read the words they agreed to. These were not rare mistakes, they were routine. Before 1900, the justice system believed certainty mattered more than accuracy. A verdict meant closure, an execution meant control. Appeals were seen as dangerous delays, not protections, and so the system chose finality over fairness. The cost was paid by prisoners who never got to tell their full story. Some went to their deaths still believing someone would stop it. Others stopped hoping long before the end. Prison letters show this clearly. Early notes ask for help. Later ones say goodbye. In the final days, many wrote nothing at all. Silence became their last appeal. What makes this era so haunting is not just that innocent people were executed, but that the system knew it might be wrong and moved forward anyway. Judges admitted doubts in private, governors hesitated, guards questioned orders, yet the executions continued because stopping them would mean admitting failure, and failure was unacceptable. By the early 1900s, appeals slowly became part of the law, not because the system became kinder, but because it had been exposed. Too many mistakes, too many dead, too many questions with no answers. Punishment without appeal had reached its breaking point. But the people who died before reform never received justice. Their convictions were never erased. Their families never heard the word innocent spoken by a court. History moved on, carrying their weight quietly. Today, when appeals take years, when executions are delayed again and again, that slowness exists for a reason. It is built on graves from the 1800s. It is built on men and women who were denied time, denied review, denied mercy. Their stories warn us. Justice that moves too fast can become injustice. A system that refuses to question itself becomes dangerous. And when the law believes it cannot be wrong, lives are lost that can never be returned. Death row before 1900 was not just a chapter in history, it was a lesson written in blood and silence. Punishment without appeal ended lives. Remembering them is the only appeal they have left, and this is where the story ends. If this story made you question justice, you're not alone. These forgotten voices deserve to be remembered. Subscribe now to uncover the truth history tried to bury, because some stories are too important to be silenced.